Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So, of course, please subscribe to our channel. Today I want to talk about appeals. There's a perception in the general public that if you don't win, you appeal. You lose your case, file an appeal. There's a court of appeals that's you drive up 67 miles up the road to Lansing, file your appeal. That's what people think. Well, I got to tell you, the appellate court is there to address things that go on in the lower court that don't meet with the person's satisfaction. But it can't be just that. It can't just, the Court of Appeals does not exist because of sour grapes. It's not a function of the fact that you lost, so, you feel bad about it, take your chance with the Court of Appeals. That's not how it works. The Court of Appeals, generally speaking, works on the notion of assignment of error, meaning that the lower court did something wrong. When you file a brief for appeal, you have to, there's a section called question presented. What question are you bringing to the Court of Appeals? And the question presented is usually something like, did the lower court make a mistake in admitting this evidence when it should not have, or in disallowing something that it should have, or in taking this testimony when it should have been deemed irrelevant, or considering this factor when it should have considered that factor? That's how these questions are presented to the Court of Appeals. Notice what that means. That means that you have to assign an error. In other words, it can't be that you don't like the result. It has to be that you don't like the result because somebody did something wrong. Just because the court decided to give dad custody instead of mom doesn't mean that that's appealable or not successfully appealable. I suppose you can try to appeal anything, but if you want to hope to have success on the merit, you're going to have to show that the judge did something wrong. The lower court erred in doing A, B, and C. It's going to have to be something that your attorneys can articulate and point to in the transcript and be able to say to the Court of Appeals, you see this? This is what the court did wrong, and had they done it differently, there would have been a different result. Many times the Court of Appeals will say, we agree that had we been sitting as the trier of fact, we might have decided this case differently. But that doesn't mean we're reversing. Just because we don't agree with the court doesn't mean we're necessarily going to find that it's something that's subject to reversal. It's not enough to find that they did something wrong. They got to have done something wrong and it would have made a difference. The court often says, yes, the assignment of error is correct. Yes, this judge did something wrong. However, we find the error to be harmless because the overall decision would have been the same. So, in other words, when you talk about appealing to the Court of Appeals, you have to understand what they're there for and what things will likely cause the court to say, yes, we're changing the lower court decision. We're reversing and remanding for further proceedings, that kind of thing. If you have any questions about your case and whether or not it qualifies, reach out and we'll be glad to help you out.